Sujasmasi, Madam Speaker. Madam Speaker, I rise in support of Bill 32, and I do so as a mother and as a biochemist. I studied general chemistry, organic chemistry, biology, anatomy, physiology, and biochemistry at the University of Washington. And as someone who loves science and who loves policy and who loves our island, this measure and this debate has been a great exercise. And I want to thank my colleagues and I want to thank our staff who has helped us to contribute to all of these amendments and to bring this measure to where it is right now. At its best, data is supposed to clarify the public debate, not distort it. Good or bad, pro or con, in favor of or against, the data is supposed to be driven by the scientific method, not deeply rooted public opinions. But in a world where information is at our fingertips, unbiased, scientifically rigorous knowledge is harder and harder to find. A generation ago, everyone was entitled to his or her own opinions, but no one was entitled to their own facts. Now, everyone has a scientific study. Every nightmare scenario can be preceded by a new study shows X, Y, or Z. A previous speaker had mentioned the Information Quality Act. And recognizing the horrible impact that bad science could have on public policy, the US Congress passed what became known as the Information Quality Act in the early 2000s. The Information Quality Act requires federal agencies to employ sound science in making regulations and disseminating information. It also provides a mechanism for people and companies to challenge government information that they believe to be inaccurate. Business, consumer, environmental, and conservation groups have all used the IQA to pursue changes in government policies. Under the IQA's guidelines, the term quality encompasses utility, objectivity, and integrity, meaning that the information should be useful to the public, should be secure from unauthorized revision, and should be objective in its presentation and its substance. In order for public information to be considered objective, it must be presented in an articulate, an accurate, clear, complete, and unbiased manner. Agencies must present the information in the proper context and identify both the sources of the information and the methods used to produce it, along with full documentation so the public can access whether there may be a reason to question its objectivity. The information must be accurate, reliable, and unbiased, and based on sound research methods. Information that is influential, scientific, financial, or statistical information. That is, information that has a substantial impact on important public policies or private sector decisions, also must be reproducible to demonstrate its objectivity. But why should the federal government's Information Quality Act matter to us? Madam Speaker, because some of the information shared on this floor, some of the alleged science sent us over the weekend is so bad that the federal government can no longer represent it as the truth. In 2017, after months of public pressure, the Drug Enforcement Administration, DEA, has removed factually inaccurate information from its website. The change comes after Americans for Safe Access, which is a national nonprofit dedicated to ensuring safe and legal access to medical cannabis for therapeutic use and research, filed a legal request with the Department of Justice last year demanding that the DEA immediately update and remove factually inaccurate information about cannabis from their website and from their materials. Americans for Safe Access argued that more than 25 false statements on the DEA's website about cannabis constituted a violation of the IQA, which requires that administrative agencies not provide false information to the public and that they respond to these requests for correction of information within 60 days. One publication, and I quote, "The dangers and consequences of marijuana," contained 23 of the 25 factual inaccuracies in violation of the Information Quality Act. Such inaccuracies included claims that cannabis was a gateway drug, that cannabis caused irreversible cognitive decline in adults, that cannabis contributed to psychosis and lung cancer. Madam Speaker, if this same bad science isn't good enough for the US Justice Department and the DEA, it shouldn't be good enough for Iles Litera and Guahan and the people of Guam. Moreover, Madam Speaker, I know that every mother, every parent in this hall shares the same goal, regardless of their views on this debate. We all want our children to grow safe, successful, strong, wherever their lives may take them. For that reason, I ask you this: what do Harvard, the Air Force Academy, MIT, Georgetown, Microsoft, and Amazon all have in common? All of them, every single one, are located in a place where adult use of cannabis is legal. And amid all the bad science, all the fear that this debate can spread, one simple fact remains true. 10 states and Washington, D.C. have legalized the adult use of cannabis since 2012, and not a single one has repealed their laws and gone back to prohibition. Not one. Each of us understands the immense power of public opinion in the political process. With it, anything is possible. Without it, great ideas die before ever seeing the light of day. So why aren't there a pack of politicians racing to repeal these laws in each of these states? If adult use cannabis makes us unsafe, then why isn't there a massive movement for change? Madam Speaker, I have taken a long time to think about my position on adult use cannabis and my position on Bill 32. And while no thoughtful scientific evidence has caused me to doubt my support for it, parents generally hate the possibility of increased risk to our kids, no matter how small. This is why I was shocked to learn that some lawmakers, some countries sought to legalize adult use cannabis not to make money, but to protect our young people. In a 2018 interview, Prime Minister Justin Trudeau was asked about how much the Canadian government could collect from the adult use of cannabis. He didn't know. Trudeau argued that so long as it was easier for young people to buy cannabis than it was to buy beer, Canada's youth would not be safe. Drug dealers won't card you to make sure that you are 21. Drug dealers don't have to tell you how the cannabis was grown, what was added to it, or how strong it is. Drug dealers don't have to be licensed. Their places of business are never disclosed to the public or subject to inspection. Like many policymakers, Trudeau argued a simple truth. Pretending you don't have a problem doesn't make it disappear. Madam Speaker, no one regulates drug dealers or the criminal enterprises that they engage in. And we know that the profits from the illegal sale of marijuana are often used to buy dangerous drugs in distribution quantities. We know cocaine mysteriously lands on our shores, and that crime overtaking our streets comes from meth, not marijuana. With this vote, we can dramatically decrease the profitability of illegal marijuana. We can regulate cannabis and make it safe. We can hurt drug dealers and cut off a vital part of their income stream. Because science, common sense, and popular will throughout the country seem so supportive of acts like this, some have said that we can't pass this bill because it would be against federal law. This body's legal counsel is clear. We have a sound legal basis to act. And now, that same opinion is bolstered by Carlo Dizon, a practicing attorney on Guam and a graduate of Yale, the London School of Economics, and Stanford Law. On this topic, Carlo writes, and I quote, "First, while Guam law flows from the Organic Act, it would be inaccurate to say that, quote, all Guam law is an extension of federal law," close quote. The Ninth Circuit has recognized that Congress in the Organic Act evidenced clear intent to allow Guam to develop its own independent institutions. EIE Guam Corp versus the Supreme Court of Guam, Ninth Circuit, 1999. That congressional intent also, quote, allows the Guam Supreme Court to develop Guam's common law and to develop sufficient legal traditions and precedent. And that's Hauser v. Department of Law, Ninth Circuit, 2004. And the Supreme Court of Guam has recognized that the Guam legislature may play a role in defining common law. For example, in GIAA v. Moylan, the Supreme Court held that common law powers and duties may be subject to increase, alteration, or abridgment by the Guam legislature. That's us. Because criminal law derives from both statutory and common law, one can argue this bill has roots in common law and thus would be part and parcel of Guam's ability to develop its own independent institutions. At the minimum, because of Guam's ability to define local common law, it would be oversimplistic to state that, quote, all Guam law is an extension of federal law. Second, Attorney Trapp's comment appears to conflate two issues. The federal scheduling of cannabis as a controlled substance on one hand, and the federal enforcement against illegal possession of controlled substances on the other. On the first issue, Congress has shown no intent, through the Organic Act or otherwise, for the federal schedule of controlled substances to preempt Guam's schedule. And Congress has such power to compel, for example, the Organic Act requires our tax code to mirror the federal tax code until we establish our own. Because the Guam legislature has retained the power to schedule controlled substances, it should also have the power to deschedule them. Finally, Madam Speaker, the truth is, even if this bill passes, we aren't done yet. Rules and regulations must be submitted to this body within 1 year of the statute's enactment. That means this law cannot be effective without a second layer of legislative concurrence under the rulemaking process. And like every jurisdiction which has legalized cannabis, our laws can and should be fine-tuned, as a previous speaker had mentioned. They should evolve. Put simply, colleagues, while this bill might buy the car, no one gets to drive it off the lot without a license. And that is the license we will provide by adopting, rejecting, or letting lapse the rules of this program. If you are on the fence, If you think you need more time or more evidence to decide, consider allowing this bill to pass. Help us with the amendments. And let this process continue. Allow the governor to impanel the commission, allow them to submit rules, regs, and an EIS to us. And then let's decide whether we're taking the car off the lot. But for now, let's allow the process to continue. And Madam Speaker, let us choose progress over paralysis. And with that, there are 2 amendments that I'd like to proffer. I think they've been disseminated to my colleagues. The first one is to add a new Section 17 to the bill. Does everybody have that? It's titled Independent Economic Impact Statement.
Page 29, line 11, yes.